do it after prelim or plea, but that's not as helpful when it's after prelim. It'd be easier if we had it from the jump.
This is true.
The Sentencing Commission won't let us do that.
I
Technically, technically, we, according to them, we're not supposed to be doing it anyway. So it's a real source of whatever. So I stay out of it. It's above my pay grade.
They got in trouble for doing too many NCIC checks.
Yeah.
That sounds right.
All right, let's roll. We're going to be on the record in case number 2020 CR 75, captioned State of Kansas versus Dionta Washington. Would the parties announce their appearances, please?
May it please the court, the state appears by Assistant District Attorney Taylor Hines via Zoom.
May it please the court, Mr. Washington appears via Zoom with counsel Deborah Erickson also appearing via Zoom.
All right. Last time we were all here was back on April 16th, at which time the defendant changed his plea from one of not guilty to guilty. The court inquired and accepted that, ordered a pre-sentence investigation, and set it for sentencing today. I've received that pre-sentence investigation. The critical findings are as follows. The sole count of conviction is one of theft of a firearm. That is a severity level 9 non-person felony. The defendant's criminal history score was found to be that of G, as in George. That would leave him with a presumption of probation with a presumed underlying range of 7, 8, or 9 months. If he has to do that time, he'll be eligible for up to 20% good time credit and subject to 12 months of post-release supervision. If he were to be granted probation today, it would be for a period of 12 months to court services. I would ask you first, Ms. Hines, did you have an opportunity to review the PSI? And if so, do you have any additions, corrections, or challenges to those findings?
Yes, Your Honor, I have reviewed the PSI and I don't have any additions or corrections at this time.
Thank you. Ms. Erickson, same question.
Judge, I don't have any modifications to the PSI.
All right.
And I have gone over the criminal history score with Mr. Washington, and he does not have any objections to the criminal history.
All right. Mr. Washington, your lawyer is telling me that she went over with you that criminal history worksheet and you think it's accurate. Is that correct?
Yes.
All right. I will find there are no challenges to the findings of the PSI and adopt those findings for today's hearing. This is a little bit of an unusual ask, not completely unheard of, but given that, I'm going to give Ms. Erickson the floor first. Ms. Erickson.
Judge, I assume the court means it's unusual in that Mr. Washington is presumptive probation, but he is not requesting probation in this case, Judge. He is presently, Judge, in federal custody. Ms. Hines and I had already been working on this case prior to him going into federal custody, where it was a recommendation for him to receive probation. He believes, and I agree with him, that it's a better situation for him since he has entered into a plea agreement where he offered to serve 60 months in prison on his federal case, which is his agreement is for 60 months, that he go ahead and get this case behind him rather than have it pending to have to resolve when he is released from custody. He would still be presumptive probation at that time, but he believes that it's better situation for him to deal with this case and not request probation, get the case resolved, and ask the court to sentence him to 8 months, which is the standard sentence, and to run this case concurrent with his federal case. He judged that, from my experiences with Mr. Washington, and I know the court has experience with Mr. Washington too, even though this is his first state criminal case, because you had experience with him in the Child in Need of Care court. And it would appear, Judge, that Mr. Washington's biggest issue at that time was a drug problem. He can address that problem, Judge, while incarcerated. He had a use problem with marijuana, and that can completely be resolved for him in that 60 months. If a warrant remained in this case while he's in federal custody, he would not be able to do many programs. He would not be able to do a halfway house. There's a lot of things that his level of incarceration would be greater. There's a lot of things that would be detrimental to him. So he would ask that the court follow the plea agreement in this case, sentence him to 8 months and run it concurrent. Judge, I don't know. We agreed to no fines in this case. I don't know what he'd be able to pay as far as court costs and fees, but he understands that those might be ordered.
All right, thank you. Ms. Hines, your comments upon sentencing today.
Your Honor, I agree with defense counsel that the agreement was for the defendant to serve the time and have it run concurrent to his federal case. And the standard number here is 8 months. So I would just recommend the 8 months. Deb, I would like to request though, if you have the case number that I can put on the journal entry for his federal case, that would be great.
It's on the PSI, Taylor.
I
It's
didn't
the,
see it.
oh, it's number 1 on his criminal history score.
Okay. Oh, I was looking at the current open cases. Okay, thank you.
Use possession. Oh, there it is. It did say jurisdiction code F. Okay. I thought that was a state charge. All right, Mr. Washington, now is your opportunity to tell me anything you want to know in mitigation of your sentence today.
I really don't have anything to say.
All right. Ms. Erickson, do you know any legal reason why I should not now proceed to sentencing?
No, Judge.
All right. Well, I'm going to follow the plea agreement, and I don't think there was a formal written motion, but I am going to find substantial and compelling reasons to depart from the sentencing guidelines, which would grant Mr. Washington probation. And that is, in fact, that those comments on defense counsel today, that he is serving a lengthier federal sentence, and that having this case stay active in a warrant for him under whether it would be a probation warrant or a pre-sentencing warrant would inhibit his ability to participate in programs that would lead to defendant reformation. So at his request and for those substantial and compelling reasons, I'm going to deny probation today. Order that Mr. Washington be sentenced to serve a term of 8 months in the Department of Corrections. He'll be eligible for up to 20% good time credit and subject to 12 months of post-release supervision. That sentence is ordered to run concurrently with his federal sentence that he is currently serving, which, if I am reading the case number correctly, it is 20 CR 20048.001. And if I have that in any way incorrect, I will defer to the journal entry and the other information telling us what federal case it is. Mr. Washington, I assume when you get out of federal custody, you're planning on getting employment. Is that correct?
Yes.
All right. So the only thing that I see, Miss Erickson is retained. There's 2 things that look like they may be payable. And one of them is the court costs, and the other one is the DNA database fee for the KBI. Since this is your first Kansas state felony, I'm going to assess those. The total of that's going to be somewhere in the neighborhood of, what is it, $400?
Yes, Judge.
So if I ordered you to pay, say, $50 a month once you get out until it's paid off, do you think that's something you'll be able to do?
Yes.
All right. And obviously you get that paid off faster than people stop worrying you about it. So the order will be a $50 minimum monthly payment once he's released from custody. And that will be the court cost. There are no supervision fees. There are no attorney fees and the KBI database fee. So only court costs and database fee. No fine, no restitution requested. All right. He'll have credit for all the time that he spent in jail for a case. And let's see, the advisories. Mr. Washington, you have 14 days from today to appeal anything you don't like about your sentence. You may be able to seek expungement of this conviction after a period of time following successful completion of supervision. As a convicted felon, it is prohibited for you to own or possess a firearm. Certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons. Do you understand all that, Mr. Washington?
Yes.
All right. Ms. Hines, anything I failed to cover today?
No, Your Honor, I believe you've covered everything.
Ms. Harrison?
No, Judge.
Okay, all right. Well, we will be adjourned. Good luck to you, Mr. Washington.
Judge, can I tell